this once it's put in action. So we appreciate the comments from the legal practitioners. So, Mr. Champagny, you want to lead off and give your comments.
Thank you very much, Mr. Chairman, and good afternoon to your panel members, Joint Select Committee members, persons present. Good afternoon. I'd like to, first of all, on behalf of Mr. Nico Pagan, who is here with me, and Mr. Richard Lynch, both from my chambers, to say thank you very much for giving us this opportunity to give a perspective in terms of this bill that is for consideration. Mr. Chairman, you touched on it just now and made reference to the Jamaica Bar Association and the Cornwall Bar Association. And I wish to add the caveat explicitly that the views that are being expressed here do not represent either of those associations. These views are based essentially on the practice which we engage in very often at the various courts, particularly the gun court across the island. And we hope to bring some information that may be of interest and may influence the ultimate determination in terms of this legislation. The other point that I would wish to make clear is that as council, plural, we recognize, and we may be unpopular for that, because the general perception, it seems, is that there is some hesitancy and disagreement in terms of mandatory minimum sentences insofar as this bill is concerned. However, having said that, it is our considered view here, as constituted, that the proposal in terms of the mandatory minimum is something that we would fully endorse. But we take note of certain factors that have informed us in terms of our practice day to day in the courts. So I'd make reference, Mr. Chairman and your members, to the statutory mandatory minimum sections, those being Section 5, Section 6, Section 7, Section 8, Section 9, and Section 10. And I think of import in terms of the statutory minimum. I think the focus is really in terms of the 15 years for a prohibited weapon. As I said before, we accept and we appreciate the necessity for this to be part of the new dispensation going forward. And we take note of the fact that this kind of sentence is one that would normally be meted out to someone who is found guilty on conviction, that is, in relation to murder, because the statutory minimum in respect of that is 15 years. We also take note of the fact that the Caribbean Court of Justice, in recent decisions, and which I have listed in terms of the paper that I forwarded, it would suggest that the Caribbean Court of Justice is not particularly keen on the concept of statutory mandatory minimum sentences. I say that against the background that we appreciate this idea in terms of and move towards Jamaica becoming a republic. And I think respectfully, and I say that with the greatest of respect, that the CCJ may not find favor in terms of the statutory mandatory minimum sentences. And in fact, we made reference to a particular case in which Sir Dennis Byron indicated that in relation to statutory mandatory minimum, he observed that in relation to this, the courts should always examine such penalties with a wary eye, as mandatory penalties deprive the court of an opportunity to exercise the quintessential judicial function of tailoring the punishment to fit the crime. Again, I repeat, we are in support of the statutory mandatory minimum, but I think it's important to note the, shall I say, the attitude of the Caribbean Court of Justice in relation to this. Insofar as Section 5 of the bill is concerned, I believe that consideration could be given to exceptional cases. exceptional cases. And may I just pause here to say this. Presently, for instance, and there are practitioners here who are part of the committee, the Joint Select Committee. Presently in Kingston, there are 4 courts at the Supreme Court assigned to gun court matters. And then there is one that is essentially used as a plea and case management court for gun court matters. And we have a large volume of cases on a daily basis. But there have been experiences where there are exceptional cases, and I make reference to one particular case, the most recent one out of the Court of Appeal, that is Albert Poulton and the Queen, in which you had a gentleman in his late 40s, near 50s, who was a crane operator and had for a considerable period of time resided in an area that once was a safe area to reside in. His family essentially had migrated and he remained behind. The area after time became depressed, and the police had information in respect of one particular individual. In fact, they had a warrant for his arrest. In hot pursuit of this particular individual, the police chased him to the address of Mr. Poulton, who resided at that time. It had been configured now into a tenement yard setup. Wasn't the case before, years before. And he ran into the house of Mr. Poulton, and demanded that the firearm be concealed. Within seconds, and I'm not exaggerating, within seconds, the police entered the room and Mr. Poulton said, words to the effect, "Officer, this man just ran in here, gave me this thing to put up, see it there in a pan on the whatnot piece of furniture." Both were accosted, both were put before the court. Mr. Poulton took issue with the case, it went to trial, and the learned judge found him guilty. There was really no contest in terms of the allegations, and the issue was whether or not it could be said whether or not Mr. Poulton was in transient possession, whether or not he had the intention to possess. The court found him guilty. So now, we have a 49-year-old man, excellent record, no previous convictions, and in fact, in cross-examination of the witnesses, the police indicated...
That's that jury or judge only case?
Judge only, because gun court matters, may I make it clear, these are judge-only matters. Gun court matters are judge-only matters. So the trial judge, having found him guilty, we went on appeal, and the appeal was determined very recently in January of this year. And the appeal court, comprising of the president, the Honorable Mr. Justice Brooks, found that these circumstances were unusual set of circumstances, and affirmed the conviction, but importantly, did not disturb the type of sentence that was meted out to Mr. Poulton, who was really given 12 years probation. In other words, put on probation, not a custodial sentence. I pause here, Mr. Chairman, to say that with the bill as it is now, there is absolutely no provision for a situation like that, were it to unfold a year from now, during the lifetime of this legislation, if passed, for Mr. Poulton to see less than 15 years in prison. I can well think of other instances where, again, the situation may well arise. There may be the spouse of someone who is traveling along the road. The spouse leaves a licensed firearm in the custody and control, well, in a motor car, for instance. Along the way, the person recognizes that there is a firearm in the car. There's a traffic stop, police stop. The person is in illegal possession, custody and control, knowledge. Are we to say that in that particular instance, that that person should be visited with a statutory mandatory minimum period of 15 years. So while we recognize the objects and reasons in terms of the bill, we would humbly pray that this honorable committee gives consideration to what we would describe as exceptional circumstances. Quite candidly, sir, as I said before, amongst us sit practitioners of the law at the criminal bar, Kingston to Montego Bay. And they can well attest to the fact that ever so often, there are exceptional circumstances. So we'd ask that consideration be given to that, because although the situation is one that doesn't happen regularly, the fact of the matter is that it happens occasionally. Now, I know that the committee may say to itself, well, in such an instance, the law provides by virtue of Section 42K of the Criminal Justice Administration Amendment Act 2015 for the judge in such a situation to issue a certificate for that particular person, let us say Mr. Paulton, thinking in the future. Issue a certificate for Mr. Paulton to go to the Court of Appeal to revisit that statutory mandatory period of incarceration. But, Mr. Chairman, with the greatest of respect, it is one thing to have the legislation as is. It's another thing to see what happens in practice. Because to date, there have been 2 instances where the judges have issued certificate where they believe that a statutory mandatory period of incarceration they are duty-bound to impose. They believe that it is unjust and issue the certificate. In one instance that we know of as a fact, that particular individual for the last 2 years has been in custody, awaiting the determination of that at the Court of Appeal level. So this is a kind of challenge that we have, and this is a kind of concern that we have as counsel who practice very regular in the courts. We ask you also to juxtapose this with the recent passage of the law where the prosecutor has the right to appeal. Because certainly, if a judge were to impose that kind of sentence, that would be regarded as a violation to the public's conscience in terms of the nominal number of years they have the right to appeal. So, in one context, it would appear to me that there are certain safeguards, because I make bold to say, sir, that is obvious, and I think our Chief Justice did in fact indicate that it is obvious that the Parliament has expressed some concerns in terms of the types of sentences being meted out. So that's not really the issue, but we now have a situation where the prosecutor can appeal in respect of that by virtue of the Judicature Appellant Jurisdiction Amendment Act of 2021 and the Judicature Parish Court Amendment Act of 2021. I now turn, sir, to the issue concerning the cases that come before the courts. As I said, there are panel members here of the committee who practice regularly. Of the 4 trial courts that obtain in Kingston or that operate in Kingston, I would want to say that I would not be incorrect if I were to say that 40 to 50% or more of the cases that come before those courts are instances where the police is asserting that an illegal firearm was taken from the waistband of an accused. The numbers are large, very large. It comprises a great number of the total cases that are before the courts. And what we have found, Mr. Chairman, is that but for in instances where INDICOM is involved, where they embark on some testing in terms of DNA swabbing of the weapon recovered, but for that and the result thereof, there would have been many persons serving periods of incarceration wherein the evidence would not support it or did not support it. So that's a real concern. And we are particularly concerned because of now the penalty of 15 years statutory mandatory minimum. So against that background, what is proposed here, we do not know if it's a situation where it could be incorporated in the bill, but we know as a matter of practice that when you had the establishment of INDICOM, there was, shall I say, for want of a better term, and may I put it euphemistically, a disconnect between the JCF and INDICOM in relation to the management of certain crime scenes. There were questions as to who would exercise control over those scenes, and in fact, it was borne out in a very recent case that went all the way to the Judicial Committee of the Privy Council, the Queen against Albert Dyer, where the superintendent in that instance refused to hand over a weapon that was recovered on the crime scene to the INDICOM officers. That was a very recent case that was determined. What we understand now is that there is a memorandum of understanding between INDICOM and the JCF in terms of control of crime scenes. We are respectfully proposing that in this instance, if at all possible, if it could be facilitated, I don't know if it can be incorporated in the legislation, but there be facilitation in relation to instances where there's an assertion that an illegal firearm is taken from the waistband of an accused, that as a matter of course, DNA swabbing is done. And let the chips fall where they may, because it may be of some evidential value one way or another. And in fact, may I add this, not from a defense point of view, and perhaps Member Senator Charles Sinclair can confirm this. Some time ago in the West, in the regional gun court, there was a situation where the senior officers embarked on doing DNA swabbing, once firearm taken from the person of the accused. And what that resulted in, sir, in many instances, you had persons giving guilty pleas.
May I just ask
yes.
Mr. Champagne a question? Are you saying that in all cases where a firearm is allegedly taken from the waist of someone, you can make identification association with the person via swabbing? I mean, I'm not sure if I follow that you would be able to get something by way of DNA testing.
May I answer that,
yes.
Minister? Thank you so much. The answer to that is yes. Why do I say that? Because we have the DNA legislation that was passed in 2017, where...
It's not the presence of the legislation,
yes.
Is whether the, what's the word, substance, the
yes. I understand
sample,
from a technical point of view.
whatever it is.
Yes.
Is
from
there?
It is not in all instances, Minister.
And in effect, what you're asking for is another layering of an ingredient to be proved?
No,
okay,
no,
so
not another layer of ingredient,
right.
And I'm happy for the question.
Evidentially, that is.
Yes, I'm happy for the question. It would not be another layering of the ingredient, but it would be something for the tribunal to consider. Because we, in the criminal courts, in the gun court, for instance, automatically once a firearm is recovered, it is sent to the lab for ballistic testing. And you hear cases are delayed pending the result of this ballistic test, which really and truly in the scheme of things is of no moment oftentimes, because the issue is not whether or not the item in question is a gun. But a lot of time is spent, a lot of cases are adjourned for 4 to 6 weeks on ends before a ballistic report comes back in.
But Counsel.
Yes.
I mean, it is the legal burden is on the Crown to prove its case, and you have to prove
Yes.
that what is recovered is a firearm
Yes.
in accordance with the law.
Yes.
It is only when someone has pleaded guilty that the burden, there is no burden to prove anything, because you would have admitted, but even in those circumstances, there may be dispute around the facts.
Yes.
So I'm not so sure
Yes.
about the point that they have to go for testing. I
Yes.
understand the point
Yes.
on the time it takes
Yes.
to get back the certificate,
Yes.
but I'm not sure on the other point what you're making.
Minister, it was mentioned in the context of another layering when reference was made to that, because I'm saying here it is, we have a situation where there is an exercise in terms of getting a forensic ballistic report. And I'm saying at the same time, no prejudice will ensue in terms of a timeline if that was done. And may I add quickly, because I think it's important for this committee to be aware of this, that presently, as I said before, there are 4 trial courts for gun court matters, and there is 1 that deals with case management. And in that particular court presently, in very recent times, whenever there is the allegation of gun being recovered from the waistband of an accused person, we have realized that we are getting now, I don't know at whose instance, whose direction, but DNA testing is done. It is done. And it is received in a relatively short period. And we are submitting that the point is that whereas we have to be hard on criminals in terms of those who should be penalized.
Yes. DNA lab has just been fully equipped. So
equipped.
It will be more readily used now.
Yes, sir.
I'm saying that it has to be used in this case, but DNA as a source of evidence and material is now much more easily accessed and used. The lab is in good condition.
Yes. And I think that has tremendously contributed to the speed at which we are now getting those results. But we say all of this to simply say 15 years, statutory, mandatory minimum, possession simpliciter. We want to move the discourse in the way of evidence from the mere say-so of a police officer. That is what we are concerned about, because experience has shown in a number of cases, the Queen against Xavier Thompson, the Queen against Leonard Campbell, the Queen against Keon Francis, these are all recent cases where, but for the DNA result, the outcome of the case would have been different. So we ask that consideration be given to that. Mr. Chairman?
Just to clarify, through you, Chairman, I understand your point on use of best evidence or most reliable evidence, which would include the DNA, but I do depart from you on the point that the submission of the firearm would be an additional layer. It's a necessary ingredient in proving the offense.
No, I agree. I have no issue with that, Minister. I merely mentioned it because sometimes when this argument about DNA is raised and the testing, the concern will be a valid concern, that why would we want to do that, because it's going to take up considerable time. And I'm simply saying that time is already expended in terms of trying to get a ballistic certificate, and especially in light of the context that the chairman has said, and it is bearing fruit now, where DNA results are coming in quickly.
Mr. Champagne, as I said, I understand the comment. I appreciate it. As I said, the 2 points there is, and I intervene because I think there are 2 major points you have brought to attention. The question of a kind of inadvertent holding of a firearm or transitory holding, as I said, and in this case of the real issue you're bringing here, one in this case of DNA, is essentially a verification that the linking of the firearm with the individual is beyond doubt.
Yes, sir.
I think that's really what they're asking.
Yes.
And I think it's a valid point, and I wouldn't want to diminish it in any way. I don't know if I want to put in the law the DNA identification as a final thing, as you say, as it is 15 years mandatory, is like a homicide case, and that's how we're regarding it. A gun is a killing weapon.
Absolutely, sir.
That's
Absolutely.
what it is. And therefore, this will be part of evidence, as far as I'm aware, in these cases. But I know if if I put in law, and
I'm not suggesting that we
case,
do that, sir. I'm
Yeah.
simply saying that, and that is why I made the analogy to Indicom and the Memorandum of Understanding with the crime scene.
Bear in mind, I said the
Yes.
police itself, because some of the, a lot of things are happening, so to speak, if I might use layman's term, in more terms of criminals getting more brutal and changing their style and new criminal activity in the virtual space, scamming, etc., which changes the criminal landscape. The pathology of crime changes. So, but we are taking some steps. There are some changes in the police, and a lot of this thing end up on the professionalism of the police and their capacity to investigate cases thoroughly. Bear in mind that the commissioner, I think, recently documented online for the police investigators a 3,000-page document and evidentiary material for prosecution
Yes,
before
sir.
they come, and have increased their cooperation with the prosecuting body. So there's a process involved, and this, both items have to be borne in mind, because we realize there are, the exceptional case of someone going off to be charged. And there are aspects of it which has to be examined, and we are conscious of it. I said the object of introducing mandatory sentence is not so much to interfere with the court, but to send a strong message out
We
there
understand, sir.
And I think you
Yes.
appreciate that. And we have had cases. There might be some areas, it's not so much changing this, but we have to maybe examine it some more in terms of what else can impact on this in law. And recently, I think Mr. Senator Sinclair is on, and among, he brought to my attention some amendments to the expungement, which where even when the person gets, he may get relief if they are convicted, they cannot get expunged for,
Yes.
for firearms. So some of these new legislation have been looked at in that context.
Yes.
You don't even want one person to be, the severity law, you don't want to fall through the crack. But in reality, we're all human. The circumstances, as I said, justify this, but we have to look clearly at how we can ensure that we
Thank
don't
you,
have
sir.
a clear gap, and we certainly examine it. And these two items are maybe two of the ones that will always create room for concern. Okay? You don't
Thank you.
want anyone being sent away for possession of a firearm when he's not the person. But the possession of the firearm is today the critical component in the murder cases. So we'll have to examine it, but we have to maintain, I said, a certain rigidity in this particular piece of legislation.
That is appreciated, sir.
But, Minister?
I thought, Queen's Counsel, you were asking for some provision in the law in respect of DNA evidence. But in answer to the chairman, you said no.
No,
So
not
you're
provision.
not asking
No,
for the
no.
law, but in terms of the investigation.
Yes,
as a
yes,
matter of
yes,
course.
yes, Minister.
In that case,
Yes.
then I can totally understand where you're
Yes,
coming from.
yes.
And in respect of the previous point, if I may, Chairman, on the mandatory minimum. So you do realize that the law does have a scheme for the provision of information by someone,
Yes.
which will then determine the extent to which you face the law.
Yes,
Where
Minister.
firearm is
Yes.
recovered, and that was part of the mitigating
Yes.
mechanism in the
Yes.
law. But your point on whether, as a matter of policy, a consideration should be given for going below the mandatory minimum, where someone has pleaded guilty, and in particular where where the circumstances do not reflect the most egregious example of the commission of the offense, is one that can be considered. But you do understand from what is stated at clause 3 that the law, as a matter of policy, views possession of firearm that has not been authorized, and in particular
Yes.
firearms that have been illicitly trafficked, as extremely egregious.
Indeed, Minister, indeed.
Extremely egregious,
Indeed.
simply because of the havoc
We
that they've
appreciate
wreaked
that.
on the society.
And that is why I started out by saying that the position here being represented by no means reflect the majority view of the bar.
But as defense counsel, you have to look out for
But
someone.
but we are here with our own views on that, and we join in
Ponder the
support.
gaps.
Well, for me, Chairman, I take the point because in principle,
Yes.
in principle, someone who has pleaded guilty is usually given a discount for not having wasted the court's time,
Yes.
with the exception that if the plea of guilty comes
Yes.
because of the certainty of conviction on the strength of the evidence,
Yes.
then the court is not, the court does not have to discount the sentence in those
Indeed.
circumstances.
Indeed.
But and then part of the concern around sentencing is how the plea provisions have worked in a way that almost appears to be a backlog reduction mechanism,
Yes.
without striking an appropriate balance
Balance.
between what is appropriate
Yes.
given the antecedents
Yes.
and the offense.
Yes.
And I think that has to be taken into account. But I can take no issue with your asking for consideration to be given where a plea of guilty is entered.
Indeed.
But so I just say that in accordance
Minister,
with that
once the guilty plea is in,
mitigating
the
mechanism.
person can get out.
Well, there is under the Plea Negotiation and Agreement Act a provision where the mandatory minimum can be, gone around.
The Crown.
It does provide for the provision of information that assists the Crown
Yes.
in the
Yes.
prevention and detection of
I'm
it.
happy that you went
But
there.
I know your point is slightly different,
Yes.
even though there is in fact a mechanism
Yes.
in the law that mitigates.
But I'm
in
happy
certain
for the
circumstances.
input, Minister, in, that which you just raised, because I wanted to take you to the whole issue of guilty pleas, if I may, for a moment, since you're Madam, you have raised
I didn't
it.
get that.
The issue of guilty pleas.
Yeah.
I would want to take you,
Before
if
you move
you're...
on,
Yes, sir.
In these two cases we're debating, before you go into the other points you have raised, and the minister has explained clearly, but in case, I find it strange that Mr. Poulton was charged. I must tell you,
I too myself, Chairman, but I didn't want to say it because the expectation is that in certain circumstances, what I find it even more interesting is that the conviction was upheld. So for me, it's not all that meets the eye, because I will give the court, having gone through it, and then taking it on appeal.
Yes.
So,
and again, to Minister, in the charge,
I'm not totally bought into your version of it, since the court on two levels
and that is
have
why
upheld the conviction.
And that is why the authority is there for reading, because we have not, and certainly we could not, misrepresent anything in terms of
Not about your misrepresenting. I don't think you would do that. I'm just saying that I can see that it is still a case that you hold nearer to.
That is true.
I always say, bear in mind
Yes.
that you do not move from being suspected or formally accused
Yes.
to being convicted
Yes.
without going through a process.
Yes.
And there has, even where a plea is entered, it has to be where material is before the
Yes.
court that you will not be able to cast a doubt
Yes.
on.
In this instance, though, Minister, he did not plead guilty. He contested the allegations on the basis that he did not have the intention to possess. And the court found that when the man came in,
He knew exactly what was given to him.
he knew what was given to
in spite of the
him,
circumstances.
and he put it
and
on
he had
the
control over
he
it to
put
the
it on
extent that he
furniture.
put it
But
somewhere.
all of this happened within seconds.
And I hear you, Minister, not to interrupt, I hear the Minister, and you're having the legal jargon, which is beyond me, but quite frankly, on a practical note, I said I'm happy there's been some work being done by the police to look at what is required to go to charge, then you go to the prosecution and see if it's valid, because what has happened to Mr. Poulton here is something that happened extensively in a city community.
Absolutely.
I have sympathy for that, but I think the police, as they are being trained now and being approached, would take these into consideration in the majority of cases.
Chair.
I don't know if the other law want to charge, because I did see, he gave the police information. They walked in, everything was done, and I think even if he went to court, he couldn't be charged.
And I will give my undertaking to this committee to furnish the authority.
No, I'm not questioning at all. I'm just finding this case.
But Chair, I must tell
when
you.
they get there, before, and eventually too, the judge, there must be another charge from possession, because I said he had control, but under duress, because if the man who is a gunman to come in and say, look, hold this, you have to hold it. No.
And possession and ownership are not the same thing. That's true. And I think that is where perhaps the distinction may have been drawn. But one couldn't help be sympathetic in the circumstances,
I would be
and perhaps it's reflected in the sentence.
You know, Minister, I don't see, as a layman here, from a point of view, a legislator, I think this requires a course to be taught, to be looked at, and how the judge was arrived at. Because I don't think this was correct. I'm honestly, I'm not the judge in this case. I don't think the prosecution or the judgment was correct.
It went on appeal and was reviewed and upheld. There must have been evidence.
I hear it, and I'm saying this case.
I don't want my first presentation before the Joint Select Committee to cause any dissension amongst the members. So, if I may be permitted,
if it pleases you,
that's why I speak as a layman.
Oh, you're right.
A lawyer cannot challenge the Court of Appeal.
Mr. Chair, I think.
And the second area too is, you see, the question of. Well, the Court of the Caribbean Court was clear. We're not interfering in any way with the fair trial, and I agree. But the situation in the Caribbean, not just in Jamaica, is that I don't know how recent was this case that you have quoted from, but the Caribbean and Latin America has the highest homicide rate in the globe as of the last 5 years, which is why firearms is creating some pressure. And, you know, somewhere like, for example, Trinidad.
2018, sir.
Eh?
2018.
That's the appeal, right?
Yes, sir.
Interesting, because the Caribbean now has the Caribbean has the highest rate of homicide rate in the globe. 16 average per 100,000, with several countries running beyond 20, and of course Jamaica is the highest with over 45, which creates unusual circumstances, which is why the laws are being restructured and others are following suit in some areas. But it's having, you know, we have to look at all of these.
Thank you, sir.
Sorry, I think Senator Golding wanted to make a contribution.
Mr. Chairman, I want to make a point because, you know, we had a discussion on another provision a couple meetings ago, and I asked the question about whether or not we should provide, make a provision in the law. And one of the responses was that when a person is charged, there is a process, and they go through court, they go through a trial, and so on, which was a process afforded to Mr. Bolton. But, you know, I really want to underscore, and I'm saying it almost to sober my own mind, but I commend it to the committee members as well, and those who are crafting the policy, that when we are putting things in law which are going to subject our Jamaican citizens to a restraint on their liberty, we really have to examine what the circumstances are and how we do that. Because, and this is why I keep harking, Chairman, on data. Because if the data suggests that there are frequently or more than seldomly instances where cases come before the court that would require the exercise of judicial discretion because a mandatory minimum sentence would be manifestly unjust under the circumstances, then that is the kind of data that as a committee member, as a legislator, I want to see to guide my mind as to whether I would support the provision as drafted. I understand the policy. I share the concern, Mr. Chairman, in relation to the need for us to deal with illegal firearms and the havoc that they cause. But I, too, have seen instances, and I can't Queen's Counsel quote the length of time or what percentage of the matters they were, where it is the exercise of the judge with the discretion that they have that caused a defendant to escape what would have been a most unjust situation. So I just want to commend that because I I find myself reviewing my position on the basis of your submission, Queen's Counsel. I do.
That's a comment before you come back and repeat. My understanding, the clause read by the minister, there are two comments I'll make on this. The clause read by the minister, in which a plea bargaining requires the person to provide assistance to the Crown, covers that. In this case, Mr. Polton told the policeman everything he should know, and therefore immediately should have been relieved of the man. Well, should have been relieved, really. But there's the entire situation. There are two things that you have to bear in mind, too, Senator and members. And this is the challenge of the legislator. One, we are intervening in liberty of individual, but in many of the more difficult communities that we are talking, there's no liberty except the liberty of the man who controls the gun. That's just a fact of life. So Mr. Polton was under and others like him, his liberty is long gone. He moves according to the direction of the Don and the criminal leader. And it is how we can extricate the criminals from that without implicating Mr. Polton. That's the challenge I have. But I have to, the mandate, but there is no question that these people we're talking about, they have already denied people their liberty. And there are cases that also go the opposite of yours. There's a case that has been quoted to me by a very senior judge, and it was quite hard, and I know the case well. It's a man who was physically disabled, but in the case of Mr. Polton, was quite an upright man moving. Having been around the community for a long time, he was a reasonably successful businessman, and he was taken to court for possession. Now, the judges felt committed that he was not guilty of any crime. But the intelligence confirmed without any doubt he was in fact the leader of the gang. and he controlled the gang by his sheer knowledge of the community, intelligence, and the fact he owned the power, which is the firearm, and he had the respect of having grown up in the community of the younger fellows, and they did his bidding. But from the case that could be put in terms of the evidence brought, there was a very strong view that in this case he should have gone away for a long time. And in fact, if he had even gone to jail, his power would have kept him in good condition in jail because they have that connection to go. So these are some very difficult cases, but we have as you have said and agreed, we have a major challenge, and I've expressed my views over and over. Once we go over 3,500 homicides on a steady basis, we have some exceptional circumstances. We have to keep looking at them, yes, how we can deal with it. But we have to bear in mind the issues raised that, yes, one murder is too much and one innocent in jail is still too much. So we have a conundrum we have to resolve. And this is what the legislation we're trying to do here. So finally, if you note much of what you have raised, and I understand why, then you're the first person I've done where I'm giving time to it for the minister coming. 1 to 19 of this bill is a completely new section, which has taken illegal weapons out of the normal flow of the bill, which is why we repealed the act and created the prohibition, restriction, regulation. And the weapons in section 1 to 19 are considered prohibited weapons. This was something, a new approach, one we thought that would help to isolate the criminal element, yes, from the registered and authorized element. And in this, we have to find the right formula. Right. Thank you. I think Minister wants to comment.
Chairman, I understand very clearly the point that Queen's Counsel Champagny is making. Really, the ask is that in exceptional circumstances, judge should be allowed to move away from the mandatory minimum. And the question will arise as to what amounts to exceptional circumstances, and the conventional view is that that would be determined by the courts. But we're dealing with, before I get to what we're dealing with, there is reprieve because the provisions under the Criminal Justice Administration Act, yes, allows for that, but your concern is that the law should not, the convict should not have to go through another layer
Yes.
and incur time and
Yes.
expense, although you blow hot and cold because you're saying that the prosecution should await another layer to get it taken down by way of the appeal process. You don't have to respond.
Yes.
But bear in mind that when the mandatory minimum provisions were being looked at, that was a matter that was deliberated on at length. And the decision was that because the provision, albeit it does involve going at a higher level, is there in section 42K of the Criminal Justice
Yes,
Administration Act, then in an appropriate case, there is in fact reprieve.
Yes.
And that is where the decision came down in.
Yes.
I did express my view at the time when the Criminal Justice Administration Act was being passed, that a sentencing judge is best placed, the trial judge is best placed, having heard the sentence and assess all the matters firsthand, to assess what sentence would be appropriate in relation to the particular antecedents. But we're not going to get around the policy approach where mandatory minimum sentences are prescribed. It is because the lawmakers view the wrongdoing in question at such a high level and so egregious that, even in the most, even in your best case scenario, you have to understand that if you go down that path, this is what you're likely to face. Because the harm
Yes.
is so great. And I don't think there is any dispute about the harm that the firearm, use of the firearm, especially the illicitly trafficked firearm where you can't trace, has done to the Jamaican society. So there is always a give and take. I can tell you this is a matter that we really deliberated on and came down on the side that there is another level in the appropriate case where it can be taken. And this is not to say that I'm not sympathetic to the time and cost that may be involved and the reality in the Jamaican society. But it is our hope through the mitigating mechanism, including the provision of information, so a determination can be made as to who's the real culprit, as opposed to the pawns. But it's also signaling to persons that you have to, time come when you have to choose which side you are going to be on. And when that choice is made, the state, through the other programs, will be there to support and divert you away from a life of crime. But we cannot lose so many of our people feeling that you have no choice but to take up the gun.
And that is
and
why...
cause the kind of harm
Yes.
that has been caused, harm to the, as I said in another place recently, today it is not the state that engages the rights of citizens in a negative way. It's citizens.
Yes.
Because all of us become prisoners behind the bars of our own homes.
That is true, Minister. And in
You
fact,
know, so really the takeaway is that there is a mitigating mechanism already in the law, albeit that it doesn't come just like that.
and that is a
Champagne.
challenge that I have.
Before, this has been a very instructive discussion between the two legal minds. And as I said, for a legislator, understand what you all bring up, and so to, well, three, Senator Gordon was, and four, Mr. Warden made their own point. Well, all the lawyers, because Mr. Sibley is a lawyer and accountant. As a layman, I think, beside the measures already indicated by the minister that will allow for some leverage, I think without looking at the policy again, some things could be done to ensure that there is better management. For example, maybe we'll have to look at, and it will minister be in the law, but by policy, that if a certificate is issued by a judge in what seems to be a very clear questionable case, you could put the person on community control. In other words, we have facilities for people to be monitored in the community electronically,
Yes.
while the case is being heard, as long as the police is fear that their cases that as presented is not one who is a serious violence producer, and he came in possession of the gun by a method which was clearly transient, inadvertent otherwise. So there could be something done to mitigate that problem. And also, as we as we go forward, not only making the police more efficient, and providing social alternatives, we also hope to get the courts more efficient. That nobody who has an appeal of this nature has to sit around for 2 years, whether in jail or in community monitoring.
Yes.
Because that could be done as well. So there are areas to look at to make sure that the law maintains what I say, justice throughout the system.
Thank you.
So I appreciate the contribution and really not treating it lightly.
Mr. Chair.
Mr. Williams.
Yes.
So I just wanted to go back to Queen's Counsel, to your first aspect of your presentation in relation to the DNA component. Am I to understand that you're limiting the DNA requirement, that you would love to see a DNA requirement or inclusion in relation to cases of or allegations of firearm being taken from the waistband? And that's a particular context in which you are raising the DNA question or requiring the DNA component?
When you say inclusion, the inclusion that I'm referring to, and I think it was qualified by the minister just now, Minister of Legal Affairs and Constitutional Affairs, the inclusion is not in the bill itself or the act to come, but a policy directive be given as it relates to that practice in very much the same way where there is a memorandum of understanding as between INDECOM and the JCF in terms of crime scenes. So because I don't know that I would be on good footing to include it in the legislation. It would definitely be another layer then, in my view, and would something that would present various challenges. But when you have this kind of penalty in the wings, may I put it that way, of 15 years, to my mind, the more severe the penalty, then the more concrete should be the evidence in terms of guilt.
I do, because from a defense attorney perspective, and I know your submission is rooted in your significant years of experience practicing in the criminal courts. Is it that in relation to firearms, allegations that firearms have been taken from the waistband of an accused person, your position is that DNA testing it would assist in determining the question of innocence or guilt?
It would assist along the way, yes, sir. One way or another.
One way or the other. And you have mentioned that there are a lot of cases where it would assist in the sense that it has eased the backlog, because
Absolutely.
most persons faced with the DNA results yield or give up the ghost.
Yes.
All right, so you speak specifically to the waistband case. Now, there are other issues.
From the person. Doesn't have to be waistband.
Waistband,
Yes. From the person.
From the person. All right, so so what about a factual circumstance that involves a motor vehicle where a firearm is found in the motor vehicle?
Happy that you asked that question, because as I said just now, over the last couple of months in Court 6, the gun court, that is being done routinely, where there is a driver, for instance, and there's a presumption in law that the driver, which is rebuttable, is deemed to be in possession of the firearm, but still in those instances DNA is done, and it has served its purpose in terms of the ultimate ends. In fact, some of those cases do not move beyond the mentioned court after the results have come in. Either a plea is given, or with other factors, the case in respect of one particular individual is re-examined. So it is not necessarily confined to from the person, but certainly faced with this 15-year statutory minimum, mandatory minimum, it is something that I would strongly urge the policymakers to examine and to seek to have a common ground as between the JCF and their investigation.
Question arising quickly on
Yes.
that QC. Is there a provision in law, as it stands now, whether legislatively or at common law, for a defense counsel in those circumstances where a firearm is alleged to have been taken from its client's waistband to request a DNA, to request DNA testing of the firearm?
Not that I'm aware of. I know that from a prosecutorial point of view, with the DNA legislation 2017, that it can be done and it can be ordered. But I see no impediment towards an application like that. But I'm not sure that the legislation, the DNA legislation, speaks specifically to that. But I see no impediment towards that.
Stands now, a defense counsel can say,
Yes.
faced with allegations that
Yes.
a firearm was taken from his client,
Yes.
can
Yes.
request and
Yes.
ask the court to
Yes.
request a DNA
Yes.
of the firearm. I mean,
The point is that at the risk of repeating myself, with this kind of sentence, we need to look in that direction, moving it beyond the mere say-so of one officer. If I may be permitted to just complete two other points, and it is in relation to what Minister Ford said in relation to guilty pleas, and that's at page 8 of the type presentation. And I recognize that we recognize that the efficient operation of any justice system must have as a component part a feature where benefits are derived from an early guilty plea. That's accepted. One cannot contradict that it assists in the backlog of clearing the backlog in terms of cases. However, under the proposed bill as drafted, the scope of any accused to plead guilty with a statutory mandatory minimum period of 15 years, it is respectfully submitted, is greatly diminished and appears to be incongruous to the provisions of the Criminal Justice Administration Amendment Act of 2015. This act sets out a scheme and range of discounts in the range of sentencing for guilty pleas. Section 42D and 42E make those provisions. Arguably, counsel may want to suggest that the proposed bill in the way of statutory mandatory minimum sentences would be applicable only where there is an actual trial and a conviction was the result. I pause here to explain, because as is worded now, the wording of the bill speaks about a conviction, and the guilty plea in terms of the reference to the legislation does not contemplate that. So it would depend on how the court would treat what is to be determined a conviction. And I think there needs to be some clarity in respect of that. And it is set out in page 8 of my presentation. The other point that I wanted to make was in respect of section 18 of the bill, that is seeking to benefit or professing to have or have access to a firearm. And if I may just quickly summarize without making reference to the paper. Under clause 18, I should say, there is a duality in terms of jurisdiction. Someone professing to have a firearm towards the commission of an offense can be tried either in the parish court or at the circuit level. And it is my respectful view, having regard to recent events, and I'm speaking about the parish of St. Anne, where a matter involving the illegal possession of firearm was disposed of at the parish level, and it caused some degree of consternation in terms of the type of sentence that was visited upon that particular individual. That if you allow, Mr. Chairman, for this duality in terms of jurisdiction, it is going to create a problem, because if it is tried at the circuit court level, based on clause 18, the penalty is 15 years. If it's tried at the parish court level, the penalty is 5 years. And it is respectfully submitted that we are likely to be met with some criticism in terms of how do you determine, for instance, which jurisdiction the matter is tried? And in any event, based on Clause 18, which, as the chairman has said, the bill is novel in a lot of ways, professing to have a firearm, these assertions can be easily made by a would-be complainant to say that this person, in seeking to commit the offense, or professed that he had a firearm. And it is our respectful view that in relation to Clause 18, perhaps the better approach is for it to be triable in the parish court level only.
I am persuaded.
Thank you.
Mr. Richards, I think this section, what was your... No, I'm trying to go back to this. No, I'd like a comment on this. Yeah, I'm trying to remind myself of the technical, yeah. I'm not hearing it.
There were discussions around looking back at this particular provision, so I have it in my notes for us to also review in line with what Council has just said.
There are two scenarios, which is why it was done this way. But I regarded legal and the minister was legal. My understanding was coming. My understanding, there are two aspects. A young fellow could walk to a shop and say, look, I have a gun, give me that, right? Out of almost a prank. And as well as the one who could come representing the gang, say, no, remember, I'm coming from X, deliver. And the two are two different cases. That's how I think this was drafted. But I'd be advised by the legal minds how to do it. But that was the reason, I think, why it came up like that, because the one from the gang, and I think the anti-gang act actually covers that.
Yes.
It would therefore be that it's a completely different case from somebody who, because he happens to be from a particular community, can use the stigma of the community in a negative way.
Yes.
So look, I am from X, I want, and he really does fully appreciate what he's up to. And you shouldn't treat him the same way as the other. That's why the two jurisdictions would arrive.
I appreciate that.
That prosecution would now be dependent on the police deciding.
Yeah, just to point out,
Mr. Bailey.
Based on some of the thinking that went behind the penalty that we would have prescribed here, is that we were kind of matching to ensure that there was consistency across legislation. Because in the Larceny Act that deals with extortion, that was the penalty that we had mirrored.
Anti-gang also brings simple larceny into the anti-gang where it comes to a gangster.
As well as with anti-gang.
So there is, it goes across boards. I said, how to structure it, I'll be advised. But those, you can understand the two decisions.
I appreciate
and also
it.
the fact as in the anti-gang act, which deal with the gangster, that where simple larceny was brought under anti-gang legislation.
But as it is now, Mr. Chairman, there is no distinction. I understand the rationale behind it, but as is now, it is devoid of that. Yes.
All right.
At this point, I would like to invite Mr. Pagan to make presentation in respect of the paper that was done. And I would, with your leave, Mr. Chairman, allow him to proceed at this time.
Mr. Chair, your members, and other participants, good afternoon. We are at page 6 of the presentations, and I'll be looking at 2 points thereafter. The first is the anomaly under clauses 5 and 14, and then dealing with the ammunition point 19 rounds. With respect to clause 5 and 14, clause 5 of the proposed bill deals with possession simpliciter of a prohibited weapon. And under that clause, the prescribed mandatory minimum sentence is 15 years. However, when you juxtapose that to clause 14, where we're no longer dealing with possession simpliciter, but possession for use or attempt to use a firearm or an imitation firearm with intent to commit or to aid the commission of a felony. And where that person commits that offense, it is described as a felony. And then you get to subclause 14.4, which sets out the sentence to be meted there, which is a fine or to imprisonment for such term of not less than 15 years. The obvious anomaly there is that there is a discretion being given to a judge there where there is a greater offense committed, which is a felony, and that convict could find himself being left with a fine versus a person who has been found guilty of possession simpliciter, similar to the cases that we've identified, and they're left with.
I mean, this was raised by one of your legal colleagues in the committee and discussed extended. I think it was recommended to be taken out. Mr.
Very well.
Richards, Mr. Bailey.
Minister,
it was recognized as an anomaly, and I remember the discussion.
So what the consideration was at the time was to reconsider all of the penalties that we have to ensure that they are appropriate to the offense.
So this will be reviewed.
But not to take up, but to reconsider the applicable penalties.
Or to perhaps introduce a fine in Section 5 as well. Just putting it out there.
The policy position is in relation to any offense concerned a prohibited weapon, a fine will not be applicable.
And that was Mr. Pagan's view.
I was just saying to give the judge a discretion in those circumstances. Now, dealing with Section Clause 5, possession simpliciter, and then comparing that now with what obtains under the current Firearms Act. Section 20 of the current Firearms Act deals with possession simpliciter. It covers both a prohibited weapon, which includes a firearm, and it also covers ammunition, being found even with a single round of ammunition. In the proposed bill, possession simpliciter only covers prohibited weapons. And I was careful enough to go through the entire bill to examine the definitions of prohibited weapons, the definition of ammunition, and even the definition of a firearm. And the definition of ammunition is not included in the definition of prohibited weapons or the definition of a firearm. And so you have a situation where a person may be found in possession of 19 rounds of ammunition and there is no offense committed under the Act or the proposed bill. So, bearing in mind the objects and reasons, we had to bring this to the attention of the committee.
Minister, I'm just confirming, because I believe clause 45.
No, you're perhaps referencing 47, but 47 deals with public spaces.
No, man, 45, clause 45, unauthorized possession of firearm or ammunition. So no person shall be in possession of any firearm or ammunition without the appropriate firearm authorization. So if you're in possession of one round of ammunition, you would have run afoul of this provision.
No, I think you're saying, Mr. Bill, that the unauthorized possession of ammunition is brought under the regular schedule in the restricted and regulatory phase of the bill, but it is not brought under the prohibited weapons, which is what is being pointed out here.
So the position was, Minister, that in relation to prohibited weapon and what would constitute a prohibited weapon specific to ammunition is that the focus is on the amount or the number. So if it is that you're in possession of 20 or more, it's treated as prohibited weapon. If you're in possession of 50 or more, it's treated as prohibited weapon. But anything below that will be covered and captured under clause 45.
I think, though, we may just have to take a relook at it. Just
Sure.
Your point is taken and your point is taken. We'll just have to take a look at it. So thanks for...
Very well. Thank you.
I'll limit that is again here, we have to be pretty arbitrary. You're just saying if you're 20 and above, we forget trading, you get prohibition treatment. You have 19 moving around with, but it's still illegal and should be treated accordingly. So we look at how we can make sure there is consistency.
Indeed. Grateful, sir.
Mr. Chairman, we are near the end of the presentation. I just wanted to say that in respect of Section 51, in terms of the restriction and the discharge of firearms, Mr. Darlene, I believe, was here earlier, and he made a very valid point in terms of persons hosting parties beyond 40 yards and firing and so on. And we took that into account, and we will not seek to persuade the committee to revisit that section. I trust Mr. Chairman and the committee members take note of the fact how flexible we are.
This is Queen's Counsel.
Queen's Counsel.
Thank you for your submission. What I say, I think you're much younger than I am, and therefore I expect you'll be here for some time around. You'll be practicing, and we did make it under the law. We'll review that. 7 years' time is a very short time.
Well, Chairman, since Mr. Champagne is calling us to commend his flexibility, permit me to then thank him and his team for coming and making his presentation.
Thank you very much, Minister. Just on a final note, Mr. Lynch would like to address the committee in respect of the FLA. With your permission, Mr. Chairman and members.
Mr. Lynch.
Thank you.
Good afternoon, Mr. Chairman, members of the Joint Select Committee, and all other stakeholders present. Now, I will be raising issues concerning the Firearm Licensing Authority in two respects concerning the review process. Firstly, although it is not raised in the written submissions, there is an issue concerning the revocation orders and the denial of applicants, the orders, in terms of the reason for the denial or the revocation. Now, the issue really concerns the matter of the right to a fair hearing. From a practitioner's perspective, when one is appealing or seeks to review the process or the decision of the authority, we find ourselves with in a difficult position addressing the concerns raised, because when you look at the reason for the revocation, oftentimes it says not a fit and proper candidate to hold a firearm license. Now, the issue that we have there is really, how is it now that we address what this concern is? And many a times, disclosure is requested by counsel or even the applicant themselves as to what forms the basis of this decision, and that information is never usually forthcoming. Even in situations where the applicant himself has given a statement to the FLA and are still unable to get a copy of the statement. So in terms of a suggestion that could be included in the bill, if it finds favor, is that there should be a provision where full disclosure should be given to the applicant, as in for the basis or the reason for the revocation of their firearm license or denial of their application or suspension.
So the law does provide for the giving of reason with a view to having the denial of the application reviewed.
Yes.
And you're asking, remind me, have we included one where it's revoked? So we have suspension, revocation, that also.
Yes, Minister.
Yes, that is good.
Covered. Oh, sorry. Go ahead. The challenge really, member Lynch, is that in some cases, I think there's, well, you can go for further review, you know, if the review board doesn't provide you with the, because there are cases where most times when that happens, well, let me say, it may have happened otherwise in the past, but going forward and in recent times, when you find that kind of generic term, adverse traits or unfit, it usually involves intelligence activity, which intelligence chiefs don't find something that's appropriate to convey to the public. There is, in which case, if the client feels still that he has to pursue this, they have to go to a judge and the judge get a chance to see the intelligence. Yes. As happens when we are seeking, for example, intercept, the judges get a chance. They have to go to that kind of situation. Because where you get that kind of generic thing is usually just said intelligence information, which you don't want to be in the public space.
Chairman.
But it is noted, and it's a matter we have discussed, and as the minister have indicated, we have had to look at it over and over,
Yes.
given the right of the individual.
Yes.
Chairman.
I understand that at times there may be very sensitive information to be disclosed, but it's just the difficulties that it puts the applicant in a position where he's unsure at times as to what he's really responding to.
As I said, because of the nature of it, oftentimes the individuals you'll find, the ones who pursue it, never case. Those who are aware that there's an issue that they will not pursue the case once they see it coming up. So it's one that can be, have to leave some flexibility. You're not going to find that too many pursue the case, even when they can usually, can afford to.
Chairman, to also point out quickly that in relation to the obligation that rests on the authority in providing the reason, that the Court of Appeal recently pronounced that the obligation that rests on the authority is simply to provide the gist of the reason. They don't have to go into the details of it, recognizing that much of the information that the authority's refusal is based on is truly intelligence, and there is a need to ensure or to preserve the intelligent material that they rely on.
And to add to that, I would say that if you know you're involved in illegal activities and you know all kind of things, don't bother apply for a firearm to then arm you to do wrong. We have too many examples of it. But on top of it, the policy behind the appeal process, because I read the paper and the point, we've noted the point, and if you had been watching the deliberations of the committee, you would have heard that the entire review mechanism is going to be revised and the
Yes.
policy behind it. So the point you've made as to the role of the minister, a decision has already been taken, and we will come back from a policy perspective in the committee and then with a report to Parliament. The FLA board is not a regular statutory board, and the members
Yes.
will be deep vetted, but the specialness doesn't go as far as to have coalition government in the appointment of the members.
I'd like to note that close in a minute.
I appreciate the point raised.
I'll make one of my junior ministers, after being in the ministry for about less than a year, in fact, had the same one, Minister, now I'm here. Within a few months of being there, say, I stopped going to certain places. I stopped visiting certain institutions. I just find myself restricted in what I say, where and how. and unless I was here, no one said, as long as you will have a better understanding, but sometimes it's that sensitive. But I agree, it's something that you have to be careful. The quality of the board, which is why we have emphasized in the law the nature of the board, the fit and proper cases, and of course, remember, several members are defined. Supreme Court Justice has to be chairman. All this is put there, and we remove the flexibility of the ministerial station.
Yes.
It's designed to ensure that there's a quality review and that nobody is abused. Wherever there's human beings involved, there are loopholes, but the fact is we have to design a system and a scheme that will allow for justice and still protect the state
Yes.
as well as the individual rights. Minister.
When I felt like I was almost in another role, I know Queen's Counsel has brought his junior team members. And
Coalition.
His coalition. And so my natural inclination is to hear how younger council make their presentation, but we are up on time. We have not taken the break, and that is because we knew you were here for morning, and I think some persons have. So it's not to rush you, Mr. Pagan, but in effect you would have understood that the rest of the submission has been responded to.
Yes, yes.
Yes.
We are grateful, and we are at an end. Thank you so much, Minister.
So you understand the
We do
coalition
understand.
business?
No.
Yes.
We are adjourning at this point, but I really want to commend Queen's Counsel and how he has brought a team and has the chambers review the law. As I have said this morning, I'm very proud of the fact that Jamaica is a liberal democracy and one of the oldest in this region. And the strength of it is to have the inclusion and participation. There have been decreased participation in some areas, so I'm very, I commend you for allowing your chamber to take time to review the law and bring submissions here. They'll all be considered. Really appreciate it.
And we are grateful too, sir, and to your members. Thank you very much. We appreciate it.
Thank you.
I think Mr. Champagne and his coalition can feel that his time here was worth the while.
It was.
Thank you. Thank you for taking the time to put forward a very considered position to the committee. We do appreciate it.
Minister, you move for adjournment?
Yes, Chairman. And may I just remind those who have not yet submitted your statutory declaration
Please do so.
that they are to be done today. We move for the adjournment.
Thank you for the reminder. Mine was done this morning. I had to send it. Normally I deliver by hand, but I had to send mine this morning coming here. So
Failure to do so might require the retaining of the coalition team.
all right, you move for the adjournment, Minister. Seconded by Mr. Siblis. Thank you very much. Further meeting here where we are allowing the clerk to put together what data we have. We have no time for another sitting before the beginning of May, if my information is right. So all the adjustments that have been made, we'll have to, with the other submissions, any suggestion, Minister, because there are a couple of other suggestions. The majority of the suggestions are covered, quite frankly.
Chairman,
most
let's confer before we send out the next instruction. Because we do have some housekeeping matters that we...
No, I'm saying we are going all the way through the month to allow the to prepare, make adjustments to what have been recommended in the various meetings.
Yes.
It's just, my only concern here is that we have a few of the numerous suggestions. I think there's only one that may not have covered everything. You know, in that a lot of the 14 suggestions that came in may already with the skeet shooting, essentially. So what there might be, the Bar Association may have some kind of Bar Association made a submission. How do we?
Chairman, let us, we had agreed to take a look at the others. We had invited those today. So between now and the next meeting, we would have some time to decide who. Sorry? No, Chairman, it's not. We cannot afford to extend the time. What is the next date? We only took to this month? Let's confer behind the scene.
Adjourned until tomorrow. Yes, please. You having it here? You're going to have this? If it's ready, ask me where. Ask them where you go. Yeah. Thank you. Excellent. Wonderful.
Jamaica, home of the resilient, passionate and hard-working. A people and a nation who have achieved and defied all odds.